Sahoo now joining us, Chairperson, Insolvency and Bankruptcy Board of India. Mr. Sahoo, thanks for joining us this morning. Let's talk about the most positive piece of news coming out of the proceedings in recent times, the SR verdict. What a milestone and victory this has been for the system. What do you feel it's going to instill now going forward?
From yesterday only, 1st December 2020, the provisions relating to individual insolvency has commenced. Individuals are of three categories. One is the personal guarantors to corporate debtors. The second is the individuals having proprietorship and partnership business. And third is the other individuals. So the first part, we are proceeding the individual insolvency in a phased manner. The first part, personal guarantors, we have commenced from yesterday. Rules and regulations for both the processes, insolvency resolution and bankruptcy, have been notified. For the proceedings, corporate proceedings which are pending before NCLT, if somebody has to initiate against the personal guarantor, proceeding will happen at NCLT. If it is not pending with NCLT, the process will happen at a debt recovery tribunal. And we hope in 3 to 6 months' time, this should become popular, this should take up, and this is in fact complements the corporate insolvency resolution where one kind of guarantor, that is corporate guarantors, were covered while individual guarantors were not covered. After making this much progress, there was a demand that there is some strain somewhere in the financial segment, financial service providers. There was no dedicated specialized framework to deal with their insolvency. But the Insolvency and Bankruptcy Code provides an option, enables the government to use this code with certain modifications as may be required to deal with some of the financial service providers. So recently government notified, the section is called section 227, and under that the regulators have been enabled to initiate a resolution process, and as you understand now, Reserve Bank of India has filed an application in respect of Diwan Housing Finance Limited.
What have been your most crucial leanings from the insolvency proceedings, let's say, over the last 3 years? And what really builds the core or the crux of these proceedings in your view?
The learning has been that there is a concerted effort among the stakeholders. All of us joined hands to make it a very successful reforms. In fact, they made it a reform by the stakeholders, for the stakeholders, and of the stakeholders. Every possible challenge has been overcome. Everyone, insolvency professional, we didn't have any of these institutions required to implement a reform, but all of them learned very fast. So today we actually boast of the best of the practices, and if you are keeping track, the recent World Bank ease of doing business in terms of insolvency, India's ranking improved from 108 to 52. So there have been several institutions have come up. Something new India has done is called information utility. Something new India has done is graduate insolvency program, which is a 2-year program for the existing professionals. On completion of that program, they are eligible to be registered insolvency professional. That does not exist anywhere in the world. So there has been all around learning. Everybody has put, there is a strong appetite to accept the reform, implement the reforms. But simultaneously, there was also a set of people who wanted to cling on to the existing order. That means generally this is spoken in the context of the promoters, but it is more in general. So when the law told that only the capable, credible people should be allowed to submit resolution plans, this obviously got some resistance, and it went, since interests are involved, and it's natural that people must explore their rights given to them under Constitution. Many of the matters reached the Supreme Court. But Supreme Court has been very gracious, very in time-bound manner, in the spirit of the time-bound resolution of the IBC, Supreme Court has disposed of all the matters that has gone there, and by very lengthy orders in matters of 2 weeks, 3 weeks, and conclusion of hearing. It has not even been in the months. So that has been the speed of the Supreme Court to dispose of the matter, to settle the matters. So things have moved because the government led the initiative, because every other regulator, securities regulator, competition regulator, Reserve Bank, every one of them did their bit to make it happen. Income tax laws were also revisited. Honorable Court, NCLT, NCLAT, all of them have been disposing of matters with alacrity.
There were recently some major amendments also made to the code. Could you also highlight those and explain how they will lead to quicker resolutions and how they're going to be adding considerable degree of improvement to the current code in place?
See, one of the fundamental thing of this law, this is a new law, is a basic structure is different. It relies on time-bound resolution, and it says the resolution plan, once approved by the adjudicating authority after following the due process, is binding on everybody, including central government, state government, local authorities, leaving no scope for anyone to come up after the resolution plan and raise an issue. In fact, Honorable Supreme Court, taking it relatively one step further in the matter of SR, it told that there is no question that a claim which was not submitted during the resolution period, that can be submitted afterwards, putting the resolution applicant into uncertainty, making difficulties in implementation. So the matter must come to an end. Another important change which also went to Supreme Court is about the timeline. The timeline is the essence of this code. After having the experience of so many implementation of so many other laws in the past and realizing their limitations, this law moved to a time-bound resolution, and in fact, nowhere in the world this kind of a time-bound resolution provision is there, though they may be doing it quickly, but law really does not mandate. The law originally provided that a process should be completed in 180 days time, 90 days can be extended, but we found that there have been difficulties, particularly since new law matters went up to Supreme Court in many cases. It took time, so some could not be concluded in 270 days, and therefore an extension of time was given by the judiciary to avoid a company getting into liquidation. So the new law provided that while 180 days plus 90 days remain intact, sacrosanct, an overall time limit of 330 days was provided with the word prefixed by the word mandatory. And that was also challenged in the Supreme Court. Honorable Supreme Court removed the word mandatory only on the ground that if a proposal has been made by the litigants or stakeholders before a court or tribunal, and that court or tribunal has not been able to dispose of a matter for whatever reason but for no fault of the stakeholder cannot be made to suffer, because the consequences of this law is that it will go into liquidation.
Okay, Mr. Sahoo, great to have you on the show. Thank you so much for taking the time out and joining in.